The Civil Procedure Code (CPC) is like a big rule book for civil courts in India. It's divided into three parts: sections, orders, and rules. While sections lay down the principles, orders give us the practical rules. They tell us exactly how things should happen in a civil court case. In this video, we're going to explain all 51 orders in simple, clear language, starting with the most important ones, orders 1 to 20. Let's get started. But before we dive in, let me tell you that there are 51 orders in total, but the first 20 are the most commonly used ones. So let's understand these one by one. Order 1, parties to suit. This order talks about who can join a lawsuit. It's kind of like a team sport. If you want to play, you need to know which players can be on your team. Here's what it covers. Rule 1, plaintiffs can join their cases together if they have the same or similar issues. Think of it like having multiple lanes in a swimming race. If everyone's swimming the same distance, it makes sense to do it together. Rule 2, plaintiffs can bring in new people to the case if those people have an interest in the case and they ask to be involved. For example, if you own a house and someone else has an interest in it too, like a bank that gave you a loan to buy it, both of you can be part of the same case when it goes to court. Rule 3, defendants can also team up in the same way. Rule 4 tells us how to deal with situations where someone dies and another person needs to take their place, like a family member or someone who owes them money. Rule 5 says that if someone brings a case on behalf of others, like a group of people, they need to make sure that everyone is really part of the group. You can't just say you're speaking for everyone without checking first. Order 2, frame of suit. This order is like a box of Lego. All pieces must fit together, and that's exactly what it says. You can't mix and match different causes of action. They all need to go in the same box. Basically, if you have several claims against someone, you need to put them all in the same lawsuit. Imagine you're making separate trips to court for each claim. That wouldn't make sense, right? So this order ensures that you settle all related matters in one go. Order 3, recognized agents. This one's all about who can speak for you in court. Can it be anyone or does it need to be a lawyer? Let's break it down. Rule 1, lawyers are allowed to act on behalf of their clients unless the client specifically tells the court they want to represent themselves. A lawyer can accept a case and withdraw from it any time before the case starts. Once the case begins, they can only withdraw if the client agrees or if the court gives permission. It is like having a driver who can drive your car but can only switch drivers with your permission or if there is an emergency. Rule 3, legal representatives can also act on behalf of their clients. Now, who are legal representatives? They are people who have the legal right to handle someone else's affairs, like a power of attorney holder. Order for institution of suit. This order explains how you kick off a lawsuit. It's like the starting whistle of a game, when to blow it and when not to. Let's see what it says. Rule 1, where should you start a lawsuit? Well, that depends on what type of case it is. Different courts handle different types of cases based on the amount of money involved or the subject matter of the case. Rule 2 talks about filing additional documents along with your lawsuit. Rule 3 tells us that once you've filed your lawsuit, the court will check to see if it belongs in that particular court. If it doesn't, the court might send it to the right court, which could end up being a different one. Order 5, issue and service of summons. This order tells us how the court officially lets the defendant know about the lawsuit. It's like sending out an invitation. Once you've filed your lawsuit, the court will issue a summons, which is like an official letter telling the defendant to come to court. This order covers how and when that letter is delivered. Order 6, pleadings. This order provides guidelines on what documents can be submitted in court. It includes your initial statements, replies, and any other documents that build your case. Order 7, plaint. You can think of this order as a recipe. It lays out all the ingredients you need for your main document, the plaint, which is like the heart of your lawsuit. Let's quickly go through the key ingredients. What does a plaint need? Well, first, you need to have the right ingredients. This means you must state your full names and addresses, the names and addresses of the people you're suing, the court's authority to hear your case, and why the case can't be heard in another court. Then you need to describe the main problem in detail, including when and where it happened, and explain why the other person is responsible. Finally, you need to say how much money or what other relief you're seeking. Order 8 written statement. This is the defendant's chance to respond. It's their opportunity to say whether they agree or disagree with the plaintiff's version of events. If they admit everything, great. If not, they need to explain why they think the plaintiff's claims are wrong. Order 9 appearance of parties. This order says, what happens if either party doesn't show up in court? If no one appears, the court may dismiss the case. However, there are some exceptions. For example, if one side doesn't show up, the other side can still ask the court to proceed with the case. Order 10 examination of parties. At the first hearing, the judge may question the parties, especially if the case involves a lot of money or a serious crime. This helps the judge better understand the situation and decide how to move forward. Order 11 discovery and inspection. This order is all about sharing information. Both sides must share relevant documents and facts about their case with each other. This helps keep surprises out of the trial and lets both sides prepare better. Order 12 admissions. This is an effort to simplify lawsuits and focus on the real issues. If both sides agree on certain facts, they should admit it. This saves time and energy that would otherwise be spent arguing about those facts. Order 13 production of documents. This order clarifies when and how to submit documents as evidence in court. It's important to follow the rules here to make sure your documents are accepted. Order 14 framing of issues. Once both sides have presented their cases, this order directs the court to identify the main points of disagreement. It's like a referee setting the ground rules for a sports match. Everyone knows what they're playing for. Order 15 disposal of suit at first hearing. If there's no dispute over the facts of the case, the judge may decide the case right away during the first hearing. Order 16 summoning and attendance of witnesses. This order explains how to call witnesses to testify in court. It covers how to ask the court for permission, how to summon the witnesses, and what happens if a witness doesn't show up. Order 17 adjournments. This order outlines when a hearing can be postponed and how to ask the court for an adjournment. There are various reasons for an adjournment, such as illness, the death of a party, or if a lawyer has another important case in another court. Order 18 hearing of suit and examination of witnesses. This order is like a detailed guidebook for court hearings. It describes what should happen step by step during a trial. It covers everything from opening statements to closing arguments, and even what happens if someone misbehaves in court. Order 19 affidavits. This order explains when and how to submit written statements called affidavits as evidence in court. Order 20 judgment and decree. This order covers the final moments of a trial. After the judge has heard all the evidence and arguments, they will announce their decision, which is called the judgment. The judgment may include an order called a decree that directs one of the parties to do or not do something, like pay money or return property. Understanding these orders is crucial for lawyers, law students, and anyone involved in a lawsuit. They form the backbone of civil court functioning, ensuring that justice is served in an orderly and transparent manner. We've covered a lot of ground, but remember, knowledge is best put into practice. Try applying these concepts to real-life scenarios. Can you think of a case where Order 11, discovery and inspection, might be useful? Or how about Order 16, summoning and attendance of witnesses? Share your thoughts in the comments, and if you found this video helpful, don't forget to hit the like button. Your support means the world to us. Thanks for watching. See you in the next one.